No, Your Honor.
Found that the accused was not arrested at Eldoret.
According to the officers who handed over me to Mr. Taalam, the officers informed me that they arrested him at the DCI headquarters.
Thank you. I'm putting to you that Ipoa released a false information to the public that he was arrested in Eldoret en route to escape to Uganda.
That is not in my affidavit.
I'm saying what is in social media is that the respondent...
Your Honor, I can only answer what is in this affidavit.
Sorry, Your Honor.
Let's not digress to those issues.
Yes.
Yes.
Let's proceed on the question of arrest. Are you aware the Director of Criminal Investigation, my friend Mr. Mohammed Amin, said the respondent is a person of interest?
That is not in my affidavit.
That's why I said, are you aware? If you are not aware, you are not aware.
Counsel, please ask me what is in this affidavit. I'm not going to, Your Honor, I'm not going to answer anything outside the affidavit.
I put it to you that based on the DCI mentioning the respondent, on that day at 2 p.m., he presented himself to the DCI headquarters in the presence of his advocate, one Keton. Are you aware of that?
If you said so.
And the DCI authorized these officers together with the advocate to present the respondent to Ipoa headquarters.
Your Honor, we have said time and again.
I'm putting it to you.
Please, please answer me ask me what is in my affidavit. Let's stop charges, Counsel.
Counsel, I've only put it to you, I've not asked you the question.
Is it in my affidavit? The question I'm asking to you is it in my affidavit? The answer is no.
The court, I'm putting to you, then I'll ask you where you are saying you are arrested.
Your Honor, I will decline to answer anything which is not in my affidavit.
I've not asked.
Then please ask.
I put it to you that the officers handed over the respondent to Ipoa in the presence of Mr. Keto. As I put it to you, for the record purposes.
Samson Taalam was brought to Ipoa head office by DCI officers.
And he did record a statement at Ipoa in the presence of his advocate, one Kiprono. Who is it?
Is that in my affidavit?
I'm putting it to you, Counsel. You are a counsel. When it's a question, I'll ask you a question. I'm only putting it to you for knowledge purposes. So now, if those are the facts, look at the paragraph you said he was arrested. Paragraph 7. I'll ask you questions from there. Read.
I have read and read. What is the question, please?
No, cool that. It's a long day.
No, it's a long day, yeah? It's okay.
The state is rich, it can bring water.
Yes.
For both of us and council. It's a long day. Can you confirm that paragraph 7 is not true, that he was arrested by the DCI officers?
The respondent was arrested by DCI officers after he presented himself and brought to Ipoa.
Do you have any evidence material to that effect? I've given you the scenario the way it was.
No. The fact that he was brought under the escort of DCI officers means he was arrested and brought to Ipoa office.
What has taken that? Let's go further.
Sorry, Your Honor, I think this will be my last objection. We hope that counsel is not proposing to court that he has an alternative set of facts which the court should take note of, because counsel is not a witness. If he wants to give us his alternative facts, we would expect an affidavit so that we also put him on a dock and cross-examine him. Until then, the only factual matters we have is the one given by the witness before court.
The only way to prove falsehoods is by bringing facts that are truthful. The affidavit is full of falsehoods. We are putting exactly the scenario, and your witness has not recounted any.
Sorry. I am a believer on the law and procedure. What I understand by the law of affidavits is that a person cannot give us factual matters, especially a lawyer or an advocate, from the bar. Right now, we have affidavit evidence given by this officer. We are having an alternative set of facts, which may be true, we have no reason to doubt it. But until we have an affidavit, all that is telling us is I put it to you, and we hope it does not go to evidence.
So just to again you repeat,
Yes.
the evidence that I'm mentioning from
That's right. Thank you very much.
not from
Thank you.
as we put it rightly, it's not giving evidence. Yes, he knows the procedure.
That's why
He's a teacher of the law.
yes, thank you. And that's why I told you which now is mature to be a judge. Thank you very much. Let's proceed, Your Honor. Paragraph 9.
Yes, Your Honor.
Paragraph 9.
Yes.
You have said what? About the position of the OCS?
Now, the respondent at the material time of the incident, he was officer commanding Central Police Station, exercising command of the Central Police Station, hence persons of influence, and has capacity to interfere with the ongoing investigations and likely witness.
Do you have any evidence to show that he was in full command of the police station?
As an OCS, what is...
I've asked a simple question. It is either you have it or you don't have it. Do you have anything, either duty roster or something showing he was on duty in command?
Your Honor, what the advocate is asking is that you are the presiding magistrate here. Do you have the power of this court? I mean, once you are an OCS, you have got the power of that station. Come on, counsel.
We have agreed that you don't have it. You are looking for it. Let me put it fine.
And
let me put it to you.
And Your Honor, just to answer also, whatever evidence that I had, I have put as an extra. Anything else which is not here is purposely done to safeguard, first of all, the integrity of the investigations. And they will be provided at the most relevant time. I'm well aware that this will not be the forum where those charges will be preferred. Yes.
So I've asked a simple question.
Yes.
Among the annexures,
There are none.
you produced an annexure showing he was in command of the police station at the time the offense was committed.
I recorded his statement and he confirmed that at the time of the incident, he was the officer commanding station at Central Police Station. In the presence of his lawyer. I have not attached in this affidavit.
The answer is clear, you have
Yes.
not attached. All that's what you are looking
Yes.
for. It's not attached there.
And maybe to answer your question, any other attachment that you might ask is not there, save for the OB extracts,
Just don't move. And you're a lawyer. When I say I put it to you, don't respond. I've not asked any question.
Why are you putting in the first place? Why in the first place? You can put it
You went to law school. I know. We have our own legal theory. Allow us to proceed. What is relevant, record. What is not relevant, leave it. I put it to you that there was the police station and the deputy was in command as an OCS.
That is not in my affidavit.
And I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
Thank you. The world has had it, so to me. Let's go paragraph 15. on the question of him likely to plan. You there?
Yes.
We have agreed there is no any material.
Yes, nothing attached.
Let's proceed.
Okay.
Paragraph 10.
We go back.
Oh, I asked you paragraph 15.
Yes.
I went to paragraph 16, sorry.
Okay.
Still no material tagged. It's either very serious material you have kept, no material tagged.
Yes, Your Honor.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you very much. Paragraph 18.
No material attached.
No material attached. Paragraph 17.
Come on.
I've gone back because there's a question I want to ask.
Yeah, please ask.
You have said about the CCTV cameras. Do you have possession of the scene of crime as of now?
No.
Who is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a police station. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Is that on off? Because I was there yesterday. It's not true that the scene of crime has been released to the police.
Then
Is it still a scene of crime or it is non-operational police station?
that question is not, it's not in my affidavit.
You've run very fast. Do not lie that is it. So you cannot, there's no material to show that.
Nothing attached, Your Honor.
Paragraph 19. You read it?
Yes, Your Honor.
And 21, they are the same?
What's the question? No material attached.
There is no material attached.
Yes.
That is very, very critical to us. Paragraph 22. I still ask you this question about the blue code of silence.
I will refer you to the High Court decision.
Tell the court. Which this is a lawyer, he knows High Court decision.
Court of Appeal decision.
Give the court that decision.
In the Titus Ngamau case, 2020. It was a phrase coined by the judge who was dealing with that matter.
And I remind you, he's the one who had that matter.
Yes.
He'll face you over that matter.
It's okay.
He's the one who had that matter. Cliff will deal with the blue code. Paragraph 23. You are now providing reasons as to why you want him to be detained for 21 days. True? From paragraph 23.
Yes, Your Honor.
What is the reason you want to detain him? In paragraph 23.
That we are yet to record critical witness statements.
Very well. Is his presence required physically when you are recording statements from other people?
His detention is required so he doesn't interfere with the witnesses.
Avoid recording statement and interference are two things. Wakili,
I have responded to your question. The reason as to why I'm seeking that prayer is to have him detained so that he doesn't interfere with the witnesses.
Very well. Does he know the witnesses?
Yes. Them being police officers, the answer is yes.
Is there anything you have shown of any attempt to interfere with witnesses? Because counsel, you know very well, the authorities, the Sagari, Duat Sagari, Cliff will ask you. The questions I'm asking is to prove, have you demonstrated by material your varmint?
Nothing attached.
Thank you. The court has paragraph 24. What are you addressing?
That we are saying if released, the security is not guaranteed due to the public anger demonstrated by the case. I've just read what is in the affidavit.
Yes.
I'm saying that the gruesome murder of the deceased has illustrated widespread public anger, and therefore, if released at this point, the respondent's security cannot be guaranteed.
Mr. Witty took us a lot about the case of Oscar Sudi. Heavily. Have you ever had a chance to read paragraph 32 of that position of Professor Justice Joel Ngugi?
Not in the affidavit.
It's not in your affidavit.
Yes.
For the benefit of doubt, you are saying you want to detain him on two limbs. One, for the safety of his life. True?
Yes.
Do you have anything to show that his life is in danger?
Nothing attached.
Do you have anything to show that he is a danger to anybody of the public?
Nothing attached.
So it is an apprehension.
Yes, Your Honor.
Thank you. It is an apprehension. Why are you swear to be court officers? It is an apprehension. And you are very aware that the National Police Service is the one mandated to provide security for everybody in this country, including the already convicted murderers. You are aware of that?
Not in the affidavit.
No. You will fail to be not understand what I'm asking. I'm asking you this question. The duty to protect life and property falls under the police.
If you say so.
And this country is not a banana country where the rule of law has broken. So it is not right to say you are preserving his life in cell. And he pays taxes. Everybody pays taxes to be protected. And that it will be there in the cases that I've talked about. Now, what other reason do you need him in cell to detain him for 21 days?
All I said.
What do you specifically want him to do?
All I have said in my affidavit.
Is there any other? But an advocate is not allowed to talk and be stoned out. Put Mr. Shadrach on board. He has just left class to come out. He was teaching here in his leg on the forum.
So, Mr. Kandai is Mr. Shadrach.
We just try to mention that it should be a difficult one. After Mr. Shadrach was taking in place legal cases, then without the application, I think it's better and we will be making a submission on that.
Your Honor, with your permission, I will ask a few questions to my colleague Mr. Jibril. Unlike my seniors, I am the software.
And I hope you are around so that you don't ask again the same questions which I have already answered.
Yes, I teach law. Let's relax.
Mr. Jibril submitted this earlier.
Yes.
The
problem is his body. Cliff, make sure he eats well.
So that we can avoid repetition.
Thank you. Mr. Jibril, I want you to confirm to the Honorable Court that indeed one person of interest in the matter surrounding the death of the late Albert Ojwang is the Deputy DIG Edwin Lagat.
Please, take the question.
I want you to confirm to the Honorable Court that the late Albert Ojwang was arrested pursuant to a complaint made by the DIG, Mr. Edwin Lagat.
Yes, Your Honor.
Thank you. You also want to confirm to the court that from your preliminary investigations, the late Albert Ojwang was arrested and put in police cell, largely due to the complaint that was made by Mr. Edwin Lagat. Is that correct?
Yes, Your Honor.
Thank you. You confirm to the court that the investigations you seek time to continue are investigations meant to assist you to unravel the persons who should be held culpable for the death of Albert Ojwang. Is that correct?
Yes, Your Honor.
Thank you. Please inform Your Honor the name of the chairperson of the body where you are coming from.
Your Honor, I think I've agreed, but what I'm going to answer is what is in my averment.
Just listen, this is cross-examination.
I decline to answer that question, Your Honor. It is in public domain who is the head of Ipoa.
Just respond. That is your work here.
I'm responding.
Please respond. Who is the chairperson of Ipoa? That is your work.
My response is it is not in my affidavit.
Yes. Just inform me.
Your Honor, you have agreed that I will be cross-examined on what is in this affidavit. The chairman of Independent Policy Oversight Authority's name or his position is not in my affidavit.
Particularly you come from that back.
Yes. Yes.
So it's
And the council knows who is the chair of the Ipoa.
Please answer the question. Who is the head of the body where you hail from?
We don't have a head. I thought does not have a head.
Who is the chair of the body?
Yes, that should be a right question. The chair of Ipoa
Answer yes.
is one Ahmed Hassan Isaac.
Thank you. Thank you. Now, you confirm to Your Honor that there was a joint press conference on the 9th day of June 2025. Is that correct?
Your Honor, I'm not going to answer anything outside my affidavit.
Your Honor, if you permit me, just to also give context why I am asking this question. Your Honor, my learned senior and friend, Mr. J.V. Owiti, went to a very large extent in explaining the authority that was made by my Lord Professor Joel Ngugi in the Oscar Sudi case. Some of the parameters that were set by the Honorable Court were two. I think that is paragraph 24 of that authority. On the question about bad faith, the question about exceptional circumstances, and lastly, the balance of the quadruple rights that the court should look at. One of the items that we have a duty and responsibility to prove to you is to demonstrate to you that indeed there is an element of bad faith in the application that has been made before you. And that is why my questions are aimed at eliciting some of these facts based on the evidence that is going to present before you. So, Your Honor, I plead with humility that counsel, my colleague, I even suppose is my senior. My senior should just kind enough. Yes, looks are deceiving, but
Yes.
Whatever you have knowledge, just answer it. You don't have.
Your Honor, order. Chair. Let me say this. Let me say this for the record. No, let me say it for the record. Your Honor, protect me. The counsel who's on the floor asking questions should only answer. Learned senior should stop looking at me. We will have the time to ask the questions if we require. The second, Your Honor, the second point I'm making here is that anything outside this affidavit, whether our chair is not within my knowledge, and please stop asking me. Anything outside this, I'm not ready to answer. It's not within my knowledge and belief. And after all, Your Honor, the application we are making is about the extension of continued detention of the a suspect. It's not about what happened on the backyard. What you are pointing is bad faith.
That's why you said
We don't need a break. No, we don't need a break. We don't need a break. 1 minute.
Please confirm to Your Honor that there was a joint press conference on the 9th day of June 2025 where the chairperson of Ipoa was in the company of Mr. D.I.G. Eliud Lagat and Inspector General of Police and others. We are not aware. Thank you. So you have not, you have no information that indeed your chairperson held a joint press conference with one of the persons who has been constantly mentioned in the death of the late Albert Ojwang. You have no information, isn't it?
Your Honor, the chair attends several press conferences.
Leave those several.
I don't follow the chair.
Thank you.
I don't follow the chair for his press conferences.
Thank you. Now, Your Honor, that is very important. You have been very honest with the court. Now, I want to return to paragraph 27 of your affidavit. Yes, paragraph 27. You have made mention that the reason why you are inviting the court to order the pre-charge detention of the suspect before court is because you have fear that he might run away from the jurisdiction of this court, isn't it?
Yes.
Have you, in your well-elaborate affidavit, demonstrated an instance where probably he was invited, he never turned up, or you have proof that he has already booked a ticket to a certain foreign land that is presented before court?
That is not in my affidavit.
No, you have in your affidavit. No,
I'm saying,
yes.
the answers that you are looking for is not in my affidavit.
No, I am asking a very straightforward question likely to attract a yes or no.
Yes.
I am asking you again. In lieu of the paragraph 27, on the question about the temptation by the suspect to run away from the jurisdiction of this court, if allowed his liberty, have you provided before this court any material?
No.
You don't have any material?
No.
Thank you. That should be all for me. Thank you. The two of them actually going to take very limited time in form of 2 minutes. So next time, Mr. Fitcher. Then I can do 125 minutes, depending on how Now, Mr. Vidril, I want you to remember the testimony that you've given us just a few minutes ago, when you told us that the scene of crime was processed and released to the relevant authorities. Is that still your stand?
No, it's not in my debate. That's my answer. Yes.
You made a representation to this court and told us that the scene of crime was processed and released to the relevant authorities. Is that correct or not correct?
No. Your Honor, the scene of crime I'm talking about.
Correct or not correct?
The cells where the deceased died has been processed and released to the relevant authorities.
Thank you. Now, can you tell us the investigative steps that you have used to preserve the CCTV and the occurrence book?
The occurrence book is a digital. It's not.
It's a digital one.
It's a digital book.
Is it with your possession right now?
No, it cannot be.
It cannot be.
It cannot be in my possession.
Have you extracted the relevant entries on that particular day?
Yes, and attached to the video.
Thank you. Now, number 2, about the CCTV, can you tell us the preservation measures that you've taken to preserve the sanctity of that CCTV footage?
Your Honor, we are a team of investigators. That aspect is being done by the forensic team.
So you can also confirm that the CCTV itself is not with the police station. It is with the forensic team.
And what was extracted is the only DVR. But the entire, you can't carry a whole screen.
Okay, that's what I want you to tell.
Yes. What was extracted is only the DVR.
Yes.
Yes.
So the DVR that records the events of that fateful day is the forensics team.
Yes.
Thank you. That's all.
Thank you,
Good afternoon.
I think you allow me to ask you just 2 questions. I'm taking to paragraph 6A. Where you received a complaint from the Deputy Inspector General of Police. Confirm?
Yes, Your Honor.
Was it an oral complaint or a written complaint?
It was a letter, a formal, yes, a letter to the DC.
Provided that letter this court?
No, it's not attached here.
It's not attached here.
Yes.
Thank you. Kindly go back again to paragraph 7, where you say the respondent was arrested and under the Lamada police station, OD number 50.
Yes, yes, Your Honor.
Who booked the respondent at Lamada police station?
The booking was done by myself.
It was done by yourself?
Yes.
Thank you. Are you aware of the law governing the booking of a person at the police station?
As per the Ipoa Act, yes.
As per the Ipoa Act?
Yes. And the regulations.
Are you a police officer or a former police officer?
I'm not a police officer. I'm an employee.
Police officer?
Yes, I've been a police officer.
You have been a police officer?
Yes, Your Honor.
Thank you so much. Paragraph 21. Now, paragraph 21, you're saying there are 4 conspirators. Confirm?
Yes.
Do you know the conspirators by name?
That is part of investigations. I cannot reveal it.
No, I'm just saying, do you know by name, not their names. Do you know them by name? Because you have said there are 4 conspirators. Do you know them? Not by name.
Okay, so we have to do
Counsel, this is what I will say. Let me answer. The thing is like yes.
Just say yes or no. Do you know the co-conspirators?
The matter is under investigations.
Yes or no?
As of now, no.
You don't know them. Thank you so much. Number 23. You have said there was the murder of the deceased was planned, executed, and their attempts to cover up. Do you know the people who are trying to cover up to the deceased?
One of them is your client.
Do you know that it's certainty?
Yes.
Have you provided evidence to that effect? Or the attempt to cover up?
It's an investigation but not attached to this evidence.
You have said that, yes, you know the client is one of the people trying to cover up. My question is, have you provided evidence that he is one of the people who is trying to cover up?
As of now, no.
No.
Yes.
Thank you so much. Thank you, Honor. That is the
I think that will be the end of the examination. the witness, we will learn now if it is once he is discharged, it is determined the basis for our next line of approach.
We like a few minutes of the exam because that follows cross-examination.
Yes, Your Honor.
My work is to calm you down completely.
Actually, I'm calm and composed.
Now, I will limit my questions back to the contents of your affidavit, many times by paraphrasing.
Okay.
What is the basis of your request for detention continuing in one line?
To complete my investigations.
On a scale of 0 to 100%, how much could you, by approximation, attach to your investigations up to now, on a scale of 0 to 100%? Doesn't have to be accurate, approximation.
49%.
49%. So I can mathematically say this as direct evidence that you're saying there is 51% of investigations to be done.
Yes, Your Honor.
So that there are questions about who is in charge of the cells, who is in charge of who is in command of the station. Do those questions relate to the remainder of the investigations?
Yes, they do.
Now to ask another direct question, are the questions from the defense some of the things you need to investigate to complete your investigations?
Yes, Your Honor.
Thank you very much, Your Honor. I'll hand over to Mr. Diaz.
It's just one question, the information. You have been asked whether you have attached any document relating to, I think it was paragraph 6A, some paragraphs you have done, whether you have attached anything to show that even the respondent is a flight risk. Why do you need the respondent in custody? Is there any reason why you have not attached?
Yes, Your Honor, the reason I have not attached what I've collected so far, the 49% I'm talking about, is that it will jeopardize the investigations. And it's actually to protect the integrity of the investigations. That's why you cannot divulge much.
Thank you very much. I believe that is all from my end.
Thank you, Your Honor.
I'm glad that you confirmed that you are now.
Yes.
Thank you.
Then allow the next phase of our team. Procedural, check out cabinet.
It depends how you
As we are, you are all asking for the benefit of
how many will be submitting.
4. There's kitchen, there's Lamat, there's the kitchen.
You okay with that?
We are fine. The only thing that we'll be asking is there something that has been filed so that it can be served, or it's an oral.
Let's see what they've done.
Yes, very well.
If there's anything you can.
We'll start with the authorities, simply. Our team serve
So just like brevity, decisions with value in separate. So this brevity just direct to the point here. Submissions there.
Your Honor, for the record, I remain Felix Keaton, and also there is another additional attorney at law, Vincent Yegon, also is part of the defense team. Present, Your Honor. Your Honor, we reiterate that we vehemently oppose the motion application dated the 16th of June 2025. And from this motion, Your Honor, there is only one salient issue for determination. That is whether there are compelling reasons for pre-trial or pre-charge detention has been settled in law, is well settled in law. And as such, Your Honor, Article 49(1)H and 49(1)G of the Constitution is very clear that an arrested person has a right to be released on bond or bail unless there are compelling reasons. Your Honor, in order to conceptualize and also problematize the issue, Your Honor, permit me to refer you to the statute, which is section 36A of the CPC, of the Criminal Procedure Code. And in order also to contextualize the issue, Your Honor, is that this section 36A was an amendment following the locus classicus in Michael Rotich, that is in Michael Rotich versus Republic, the 2016 decision, whereby, Your Honor, in this section, it lays the two-tier threshold for such an application to succeed. The first burden, Your Honor, is on the investigation, that is the Ipoa. And the other burden also, Your Honor, rests with the Honorable Court. And as said, Your Honor, under section 36A, it is very clear that pursuant to Article 49(1)F and G of the Constitution, a police officer shall present a person who has been arrested in court within 24 hours after being arrested. And now it lays what the investigation officer must do. First, he must make an application in writing. First, he must produce the suspect in court, which they have done, which we have done that. Then the second thing, Your Honor, is that they must apply in writing, and they have done that through this motion application. But now, Your Honor, the greatest issue that we must also do, Your Honor, is that under section 36A clause 3B, it states that the investigation must also adduce the reasons necessitating the continued holding of the suspect in custody. So the question that begs our attention at this juncture, Your Honor, is whether there are reasons necessitating the continued detention of the respondent. And we submit, Your Honor, in negative, that the investigations have not adduced any content reasons necessitating continued detention of the respondent. And Your Honor, my learned friend, we have already gone through the examination limb by limb in the entire affidavit. But if you may permit me only to refer you to 2 or 3 salient issues, Your Honor, in order to illuminate why this motion application is bereft of meat and substance to stand on. First, Your Honor, I'll refer you, Your Honor, to look at paragraphs 9, 10, 11, and 20 of the affidavit. They are building a case that you should continue detaining the respondent because he is likely to interfere with the investigation. we submit, Your Honor, that this is not a cogent reason. And we invite you, Your Honor, to consider the authority which we are provided, that is Republic versus Mercy Chebet. It is a 2022 decision whereby Justice Gigonyo has indicated succinctly, and I will humbly refer you, Your Honor, to paragraphs 17, 18 and 19 of that decision, whereby the High Court has set in the law that for such a threshold to succeed, the investigations must tender material information to the Honorable Court to demonstrate the nexus link that is between the respondent and the likelihood of interference. And I will also refer you, Your Honor, to also adopt the reasoning of Justice Mutuku in Republic versus William Chishti and Godfrey Kiri, whereby the same threshold.
Your Honor, this is not an objection. It's an humble plea that counsel shares the decision with us, and that it is generous enough that he also points out the paragraph that is paraphrasing, so that we are able to respond there.
Your Honor, we have already filed our list and digest of authorities dated in 16th of June 2025, and we can confirm, Your Honor, that they are there. The decisions and everything we have already furnished. It's the last decision. Counsel, the one which is on the thing is the one.
Sorry. I am looking at your document, sir. I am glad.
Thank you.
The document written respondents list and digest of authorities.
Yes, you are.
I am looking for Mercy Chebet. You are
There is another one which is it's not in the is the one you are holding.
Thank you. No, this list does not have Mercy Chebet. Does it have it?
You already have an authority, the one next to your phone.
You know what we are informing the court is that we don't have it in the list. So if he has added it, that's okay. That's what you're asking.
Then we can have the authority, Your Honor. You are already furnished.
For myself, it is applied.
Yes.
I think I'm comfortable.
Yes.
I have the Mercy Chebet.
Yes.
And I got the William one.
Yes. 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 So Your Honor, if I may,
Did you count as a William?
it appears there was an oversight, Your Honor, but I know the court extradition notice of all the citation of all the authorities which we have already provided the citation, Your Honor. So Your Honor, you have interfered with the floor of my first.
I am not in that business like my colleagues.
So what you are saying, Your Honor, at paragraph 17, Justice Gigonyo has laid the threshold and also eliminated that interference with witness undermines the criminal justice system and dents the integrity of the criminal process. And he goes on and also says that for such a ground to succeed, the prosecution must tender or must present material information to the head of the court. And the IDOS decision which we have also cited, Your Honor, the William Chishti case, whereby Justice Mutuku has said that there should be a nexus between the respondent and also the stated interference, Your Honor. So that was the main ground, Your Honor, that has been advanced at paragraphs 9, 10, 11 and 20 of the affidavit. Another look, Your Honor, of the affidavit is that, Your Honor, I will humbly beg to refer you to paragraph 24 of the affidavit, whereby you have been told, Your Honor, that the gruesome murder of the deceased has elicited widespread public anger and outrage leading to demonstrations which at times have been destructive. Hence the safety and security of the respondent cannot be at this point be guaranteed if released on bail. So in order, Your Honor, to demonstrate that such a reason, Your Honor, should not hold water is that we will humbly beg to refer refer you to the same decision of Justice Gigonyo, that is Republic versus Mercy Chebet, whereby at paragraph 20, which is also titled Safety and Security of the Accused Person, the judge lamented, Your Honor, at paragraph 21, that I have lamented time without number, and again, slide into grief. How and why in this age and time should people take the law into their hands to harm the accused? The community herein is within the territorial jurisdiction of the Republic of Kenya, a nation governed by law and order. And under the Constitution of Kenya 2010, I wonder whether the same community will derive the authority to harm or kill a suspect under trial. No one is above the law or should take the law in their hands. All are bound by the Constitution which reigns. And the community in question should let the law punish the accused. It should stop, and my view is that ground that the security of the accused is threatened by the members of the public or victim family should never, and mark my words, Your Honor, should never be encouraged to be a ground for denial of bail. Otherwise, the court will inadvertently promote or condone violence, disorder, and usurping of law by individuals or group of people. We say no more, Your Honor. Such ground should fail in limine. The High Court has settled the law on that. On the other hand, it is even the duty of the police to also guarantee the safety of the respondent. And we have also been told other issues, Your Honor, that we need time to do forensic, to subject the judges to forensic, etc., etc., etc. We submit, Your Honor, that all those reasons that have been given, it can be done without the need for any custodial order. So we submit, Your Honor, that from all the reasons that have been abused, none is cogent and none should pass the master of the law, because they have already done what they ought to have done, and any proposed investigations can be done without the need of subjecting the respondent to custody, Your Honor. Having submitted the legal, Your Honor, that they have failed to demonstrate the reasons necessitating further or continued detention of the respondent, Your Honor, we submit on the second link, whereby their statute also, Your Honor, has also given the court the latitude of guidance on what you do. And we shall invite you, Your Honor, to consider section 36, clause 5 of the Criminal Procedure Code, whereby it is stated that a court shall not make an order for the remand in custody of a suspect under subsection 5 unless there are compelling reasons for believing that the suspect shall not appear for trial, may interfere with witnesses or the conduct of investigations, or commit an offense while on release. So, Your Honor, even submitting that they have not abused that reason, there is a duty that the court also must also satisfy itself before granting any custodial order, that there are compelling reasons that the suspect will not appear during the trial. And there is no such reason that has been advanced by the state, Your Honor. And the other aspect of interference, Your Honor, we have already submitted that there are no material information to persuade you that there is a need to further detain the respondent, Your Honor. And we will say, Your Honor, on the duty imposed on the court in the two-tier threshold, that is the threshold in the second-tier threshold, which is the duty of the court, we invite you, Your Honor, to adopt the reasoning of Justice B.J. Otieno. There is a High Court decision in Ramadan M. Hassan versus DPP. It's a 2017 decision, whereby at paragraph 15 of that decision, Your Honor, it is at pages, you have found that authority. It's at pages 43 to 46 of our bundle, whereby the judge reasons this way, Your Honor, that I must add that a judicial officer before whom an application is presented seeking to limit the enjoyment of a suspect's fundamental freedom akin to the right to liberty is duty bound and enjoined by law, Constitution to be extra vigilant and not to interrogate whether the facts presented to it merit the dictate and spirit of the law invoked before it and are in consonance with the attributes and general philosophy of the Constitution, which guards against arbitrary and unjustifiable limitation or enjoyment of rights and fundamental freedoms. So Your Honor, will humbly persuade you to adopt that reasoning to be extra vigilant in granting such an application, Your Honor, because this being a temple of justice, Your Honor, you hold that mighty sword of Damascus, and you should always strike for the rule of law and nothing else. So having demonstrated, Your Honor, the two-tier threshold, that it fails in every length, we conversely, inversely submit, Your Honor, that on the other hand, there are compelling reasons to release the respondent on bond and or bail. And we will humbly invite you, Your Honor, to consider certain factors. Number one, Your Honor, is that the respondent before you cooperated with the investigation. I accompanied him, Your Honor, on the 11th of June 2025 when he was summoned by the Independent Policing Oversight Authority to record a statement under inquiry. And he did so, Your Honor, and he was released. Thereafter, Your Honor, he also presented himself to the DCI headquarters on 13th of June 2025, whereby, Your Honor, he sought assistance to be escorted to the Ipoa offices to seek whether he is required there or not. And indeed, in my company, he was escorted, Your Honor, and he presented himself, and he cooperated, and he agreed even, and he was duly booked at Lamata Police Station, Your Honor. So he has already cooperated, Your Honor. That is a factor which you should consider in granting him, Your Honor. The other factor which we invite you to consider, Your Honor, is that there is already issued in place an interdiction letter, which is duly signed by the National Police Service. And Your Honor, in order to put into perspective, an interdiction letter, Your Honor, is a sworn in a real document. We set certain conditions, which is very replica of the conditions imposed under Section 36A of the CPC, and also, Your Honor, which technically it frees, it holds in abeyance the powers of a police officer. In other words, Your Honor, it removes the thief from him. He can't do anything. And from that interdiction letter, Your Honor, which I had a privilege of seeing as anatomy, that law, Your Honor, he has been told categorically that he should report to the OCS, to the Elliot Police Station. So there is also a condition, Your Honor, to demonstrate that is not a flight risk. There are already safety mechanisms which have been imposed by that interdiction letter, Your Honor. We also invite you, Your Honor, to consider the primary consideration of bond and bail. That is to secure the release of an arrested person, as and when required. And respective of the issues, Your Honor, whether there will be any intended charges or anything, he is still an arrested person within the meaning of Article 49 of the Constitution. And as such, the rights under Article 49 has been activated. And such rights, Your Honor, should be enjoyed to the greatest extent possible. And in interpreting, Your Honor, and in contextualizing the Constitution, Your Honor, we will humbly persuade you to adopt a latitude that is beneficial to the suspect rather than the state. And in doing so, Your Honor, I will humbly invite you to adopt the philosophy of Justice Kimaru, as it was in my Corporative versus Republic, whereby, Your Honor, it's an affective from pages in from pages 22 to 26. Whereby the judge here, at least in this edition, Your Honor, conceptualized and also reiterated the importance of liberty being officials that are personal liberties, right to liberty should be respected at all times unless there are legal reasons for such person to be deprived of his liberty. And the police should only arrest a person when they have a prima facie evidence that an offence has been disclosed which can result in such a person being charged with a disclosed offence. Your Honor, the reason why we are citing this decision for avoidance of doubt is to reiterate the importance of liberty. It's not about the holding charge. So even in their response, Your Honor, they should not deal with the holding charge. This was being, Your Honor, I had a privilege of interacting with this decision, Your Honor, when my then client, Major Rotich, may his soul rest in peace, was arrested and we went all the way to High Court. And the court made certain findings, Your Honor, including one holding charge and his liberty. But the holding charge question, Your Honor, has already been, there is a mutation of law. So that is no longer applicable, Your Honor, and we shall demonstrate the reason why that decision is no longer, the question of holding charge is not applicable, is because of the second decision, which we have also furnished you, that is in Kenneth Omondi, Ocheng, and 38 others, whereby the same judge also reiterated and eliminated the law, knowing that there was a development, because between that Michael Rotich and this kind of Omondi decision, Your Honor, there was an amendment to section that 6A of the PC. So we drastically changed the law. That's why we will also adopt the reasoning of the judge, that the reason why this court in the Michael Rotich case required a charge or a holding charge or provisional charge to be presented to the court when the person is seeking extension of time was first to inform the arrested person of the likely charge that he or she may face, and secondly to inform the court on the serious nature or otherwise of the charge. So that was the reason in that development of the jurisprudence, Your Honor. So in grounding our application, Your Honor, and also we'll also invite you to consider another factor, Your Honor, that the suspect before you, the respondent before you, is still presumed innocent. That is pursuant to Article 49, I think 1A, 52A of the Constitution, whereby he is presumed innocent unless otherwise proven. So no matter the veracity, the public pressure or anything, Your Honor, he is still presumed innocent. So we'll also invite you to consider that one, Your Honor. And finally, also we'll also invite you, Your Honor, to consider that is not a flight risk. Yes, fixed aboard, both within Nairobi and also in Eldoret. And it has not even been demonstrated also that is a flight risk. So those are the issues, Your Honor, that we'll humbly invite you to consider in granting him bond or bail, Your Honor. And we'll humbly beg to ground our application on that under paragraph 3 to 5 of the bail and bond policy guidelines, which will guide you, especially on the situational analysis. And we'll also beg to ground our application also, Your Honor, and to support the same also, as per the decisions which we have cited, which we have already provided. That is the authorities, especially the Court of Appeal in Jayendra Gimji Malde versus Republic, whereby the Court of Appeal settled the issue and reiterated the procedural provision that an arrested person has a right to be released on bond or bail unless there are reasonable reasons not to be released. And also the Court of Appeal has also reiterated that now, unlike in the past, even those persons charged with serious offences such as murder are entitled to bail on reasonable conditions. And the applicant here is certainly entitled to that bond, Your Honor. And also on that other issues also, Your Honor, which you have been told that there are compelling reasons, except the question of interferences, safety and interest, Your Honor. We'll also humbly invite you, Your Honor, to adopt the reasoning of Justice Mativo, the Republic versus Zanfo Kabage, and I know my learned senior Cleveland Better also argued that matter, whereby the High Court has laid the test of compelling reasons. That compelling reasons or grounds ought to be proven to the satisfaction of the court, and mere allegations or possibility is not enough, and bail cannot be refused simply because the accused has been charged with a very serious offense, and that the burden of proving such to the court that there is one or more grounds rests solely with the prosecution, and there is no time whereby the burden can shift to the respondent, Your Honor. We'll also rely on the other decisions which we have tendered, Your Honor, the Betty Kimeyu case, which was also a reaction to the Michael Rotich case before the amendment, and we have already furnished to you, Your Honor. And as such, Your Honor, will invite you to decline the application before you because the same is bereft of meat and substance to stand on, and to invite you to unleash your sword of Damocles and to strike for the rule of law and to admit the respondent to bond or bail. And will humbly, Your Honor, suggest that he be released on cash bail or 7,000 shillings. That is what he can afford, because we also know the conditions of the officers in the Republic of Kenya. And also, Your Honor, in also making your ruling, Your Honor, I will humbly invite also you, Your Honor, to make certain policy or in your dictum to find or to make certain policy considerations. Because the reason why we are here, Your Honor, is also because of the legal edifice of Ipoa, which is created under the Independent Policing Oversight Authority Act, number 11 of 2011. Whereby, Your Honor, I wish, as the people of the Republic of Kenya, we had constitutionalized or made Ipoa one of the commissions or independent officers under Article 248 of the Constitution. It would have been good. But what the Parliament did in that Act, Your Honor...
Sorry, Your Honor. Sorry. You know, Mr. Keaton is a good friend. He has like a law teacher, like my friend Chandra Kwangui. What he's inviting to court to do, which is now justifying, is beyond the jurisdiction of this court. You cannot make policy. So he should just save us time so that we go to what this court can do. Although he had a very good point, but this court has nothing to do with it.
It was just an dictum observations, Your Honor. And this is why they do that one. They know that in what the Ipoa Act, what the parliamentarians did was to establish a weird...
Your Honor, we have objected to that side.
It's okay, Your Honor.
This court has no jurisdiction.
I withdraw, Your Honor, and we humbly beg to submit, and I beg to rest my submissions and raise their questions for me.
Okay, thank you.
Thank you.
I really appreciated your industry.
Thank you, Your Honor.
You brought it so very important.
Thank you, Your Honor.
And erudite.
Thank you, Your Honor.
So I believe the others will not have anything to say.
It is Langat. Good afternoon, Your Honor. I really go straight to what my colleagues on the other side submitted earlier in the opening statement, and more specifically on the case of Sudi Oscar Kipchumba versus the Republic. The decision which I believe they will share with you, I've just looked at it and analyzed while sitting here. This is a decision that, in essence, will allow you to dismiss the application today. I'm happy because they are the ones who brought this decision. It's a very beautifully done judgment, ruling. The tests that have been argued by my colleague under Article 49 are found in this ruling. I want to address one or two issues. The first one is the aspect of the investigations. They have made a picture, or they have painted a picture that our client is likely to interfere with investigations. Your Honor, today, the witness, in his affidavit and while being questioned in examination in chief and in re-exam, has told this court that they are in control of certain important exhibits which are not within reach of our clients. There's no way you can interfere with those items, exhibits, which are in control of Ipoa. Your Honor, the second aspect, which I believe will be addressed by my learned seniors, is the aspect which came out in the affidavit, the issue of forensic analysis. The forensic analysis of the phone, the gadgets, will be done and shall be done in the absence of our clients. Ipoa has officers capable of doing that job conclusively without any input from our clients. The attempt by the applicants to say that our client should be in custody while this process is going on should not be entertained by this court. This court, Your Honor, should abide by the binding decision in Professor Ngugi's decision and release our clients on reasonable bail, which my colleagues have suggested, and put even other conditions which our client is willing and ready to abide by, those conditions, the discretion is with the court. We therefore submit that the application has fallen short of meeting the threshold set by various decisions cited by my colleague and have been supplied to the court, meeting the requirements of compelling reasons. Finally, Your Honor, the affidavit that was filed before this court does not produce, does not even have did not even attempt to convince you for those compelling reasons. With that, Your Honor, I beg to rest my case. I'll allow my seniors to have their time. Thank you.
Your Honor, with the greatest of brevity.
Yes.
Can I hear? Your Honor, whereas my good colleagues have cross-examined the veracity of the affidavit as the point, my good colleague, if I call him Dr. Kiton, has laid the legal basis, the premise upon which creates a question in the application before you. I'm just reminded before my good colleague, Mr. Ondeta, submits in its finality to say that the application notice of motion that is before you seeks in prayer A, B, C, D. One, that the matter be had inter partes, which is what is happening right now. It is seeking in prayer B, that the respondent be remanded for 21 days pending completion of investigations. It prays in prayer C, that the electronic gadget seized from the respondent be subjected to forensic examination. And finally, any further orders that this honorable court may deem fit. I am certain, and it's a position we take, that we have no objection to prayer C. If the so would want to examine the gadget, given the fact that they are already seized and in custody of the gadget, as to whether we oppose or not, we would not control what they intend to do. Principally, what Your Honor is being called upon is to give a continuation of detention of 21 days to complete investigations. We submit, Your Honor, that in the deposition of my good friend, Mr. Jibril, that he has since the last 7 days covered 49% of the would-be investigations. I doubt that he would need 21 days to complete the remainder of the 51% of the investigations. Why am I saying this? The persuasion of my good colleagues that, Your Honor, be minded of the provisions of Section 123 of the Criminal Procedure Code, read with the Article 49(1)H, as well as G of the Constitution of Kenya in matters bail, that you be inclined to admit the respondent to a pre-plea bond condition is the positive aspect that we are all taking, and we have no doubt that Your Honor, clothed with wide powers to make such a determined decision on bail bond, would grant. But in the unlikely event that Your Honor is disinclined to grant bail bond as is being prayed, that you consider that the days so requested for 21 days are days which are more than sufficient for them to rely on. We are saying that the custodial detention should not act as a punishment, given the fact that you've been told the cooperativeness of the respondent and the clear position of the application before you, as well as the affidavit of one Mr. Jibril, which presents before you no evidence that the respondent is a flight risk, no material evidence as said is placed before you that the respondent is likely to interfere with any witnesses or investigations as they are ongoing. But most importantly, that their wish to have the respondent not granted bail is premised on his own safety, and we would only ask, is the police saying that they are unable to secure and safeguard the safety and interest of its citizens? In the threshold of that, now we plead, like my colleagues have pleaded, that to be inclined to grant the respondent bail bond pending this investigation, and I'm minded that he has been cooperative and no indicator has been placed by the investigators or by way of affidavit that he is likely to become uncooperative moving on forward in this particular investigation. And should in both link as to whether you grant bail, which we hope you do not, that the days sought for completion of investigation are in excess, Your Honor, and that if they are limited, it would not in any way prejudice the investigations, as nothing would bar the good investigators from making a return to this court and seek extension of more or further time so to conclude the investigation. As we oppose that application, we plead with Your Honor that you admit the respondent to bail bond pending this investigation, and in the event of such disinclinement, Your Honor, be considerate to reduce the number of days that the applicant seeks to hold the respondent in custody. Benign, we submit, Your Honor.
Okay, Your Honor, I was thinking that my colleague Shanda was going to say something. But let me start with whatever he wants to add, he can add. But
The last committee submits to
yes. Okay. Now, Your Honor, let me start first of all by asking that let me request that the court, first of all, Your Honor, grants bail to the accused, I mean to the respondent in this matter. Please grant him. And I'll be requesting the court very humbly to do so. Why am I saying this, Your Honor? It's because now I believe that once they have come under Article 49G and 49(1)H, they have an obligation to give you compelling reasons. It's an obligation. It is nothing less than that. Your Honor, if then they have failed in that particular point, what then becomes of that article? Doesn't it become absolute once they fail? And I'm saying they have failed at least miserably. Why am I saying this, Your Honor? Because if you look at Article 49, and this one was also in the Republic versus Oyamo case, the court has indicated what is supposed to be a compelling reason. That's in paragraph number 23. Tushapatia mengi mkonazo mpaka tumechoka, sio? What does the court say something to do with complaints? And this is the Court of Appeal in the realm of Justice Republic case. It must be something that is forceful, something that is so convincing, something that is so strong that the court cannot ignore it. Cannot ignore it. Now, Your Honor, once we have seen that, then the state has come and told you they want the suspect or the respondent to be in custody because they want to investigate or they want to have access to his phones. What they did not tell you is that he gave them the passwords and they're keeping quiet about it. And if they want the password, we can give it here in court now, so that that point ya kutaka simu is out of the window. Let's finish that one. It's a simple thing, a 1 minute thing, doesn't need 21 days. They tell you that there are CCTVs that are within Central Police Station. And that the suspect, the respondent might interfere with them. But the investigating officer has told you clearly they have taken the material that was required. He called it a DVI. That is the most important one. So what they have there is a shell. And that's the reason why they can't pick it, and that's why the OCS here cannot pick it. So that is the second point. That issue about the CCTV, we kill it right now. They have nothing on it. Then they're telling you they are going to interfere with the investigations. But in his affidavit, and what he has said here on oath, is that, in fact, I've given you a password. Take a password. They're telling you.
So we don't have to take it.
Yes, Your Honor. The issue is not about the SIM or the password. It requires a lot of things.
No. Your participation, watching me. I'm running the show.
Okay.
Now they're telling you about witnesses. They are not telling you the affidavit which witnesses, but they're telling you something else that is imaginary. That they are yet to get some other witnesses who they are going to record their statements. What does that show you, Your Honor? That the OCS does not have the names of those witnesses or does not know them. Does not know them. Such that if we come then to the issue of witnesses and interference with them, it is finished. One of the reasons that the court wants to grant bail to an accused person is whether he's going to appear in court or will appear where is required. Why is this important? Let us look at the antecedents of the respondent here. When the IO here called him, did he appear? Yes. When he was told to go and record a statement, did he appear? He did, and recorded a statement under inquiry. When the DCI director himself spoke and made some wild allegation in Parliament, the OCS woke up by himself and took himself to the DD police station, headquarters CAD, and asked, do you need anything from me? Look at this kind of person we are talking about. Do you need anything from me? Then they arrested him. Why would you deny him bail, Your Honor, when such a person has exhibited a person who is capable to cooperate and even volunteers before they get those Subarus to go and pick him? He volunteers. So today, we are talking of a person who knows the law and respects it. Those are the grounds that they had for you today, Your Honor. So what else remains? Now let us go back to that issue of the detention. Then have they convinced you, Your Honor? And I am saying they have not. And that is why I will agree with my learned colleague that if you gave him a cash bill of 7K, that is fine. In fact, for me, I'd say freedom. Because at the time he was going to those officers, he was okay. There was no money, there was no cash bill, but he went. That shows a person willing to come to court. They quote Article 19, they quote all those articles in the law. But you see, Your Honor, today, let us agree. Why do we have these fundamental rights? It is so that we can protect this kind of person from this kind of people. The police. That is why we have these fundamental rights. And Article 19 is quite clear, and it's my favorite, that these fundamental rights, who do they belong to, Your Honor? They belong to an individual and not the state. Not the state. Once they know that those fundamental rights exist, they come to Article 20, which is very clear and says it binds all state organs, including the court, including the prosecution, and including the officers, the police officers. That includes also Ipoa. If it includes them, today they come with an affidavit and tell you, denying bond on very flimsy grounds. Did they read Article 21? I am certain that they ignored it because Mr. Whitty, my friend here, would have told them. And I don't know why he's not telling them, but Article 21 is clear that when these fundamental rights are known to exist, all these arms that I have mentioned, what are they supposed to do, Your Honor? They must start by wanting to grant this fundamental right. Article 20, sub-article. Might start by wanting to grant to ensure that this person enjoys the fundamental right. But they still give you this affidavit. So what do we do, Your Honor? Article 22 is clear. Once we have noted that they are in a position where they want to prevent an enjoyment of these fundamental rights, we come under Article 23 and Article 165. Very clear articles. So that the court, once it has noted this kind of, can I call it, bad faith application, will be able to see. Let me qualify it to say, why does it come under bad faith? You have an IO who has come to court today. What does the IO do? Refuses to answer questions. He will not answer that. He will not say anything. He doesn't know anything. He doesn't even know who his boss is. And he doesn't know whether he attended a press conference. Now, things that are in public domain, and we know them by ourselves. Why should you believe him today? That once you release this person to him, he shall be treated well. Why? You cannot believe him because he denies publicly even his own boss. I know now how Jesus felt when Peter just and then, you know, if that is a position, and then they come and tell you, oh, this, the public order and issues like that, and that the safety of this person depends on them keeping him in custody. Where does that come from? Because Article 29 is clear. This gentleman must enjoy his fundamental rights. The security, it is provided by the state. It is guaranteed. Guaranteed. So they can't come here by a mere application and tell you that he cannot be safe. And they don't quote that article in their application. Why? They avoid it intentionally because it is black and white and it is clear. So bad faith again from the investigating officer. And he's my friend. No, Your Honor. I know when the state wants to respond, they will start telling you about probabilities. They want to tell you that nowadays it's on probabilities whether a person will appear or not, that they anticipate. And you can see from their affidavit, they are alleging, they are saying likely to abscond, likely to interfere. It remains likely. Let us change that scenario of likely. Let us move from the bail bond issues first of all. Let us go to what the law says today. Law is very clear, and there are three authorities that I will give the court. One I've already given, the one of Oyamo. Then there is one of Richard David Alden versus the Republic, that is the number 40 something. Oh, you see, I'm even so confusing myself here. The High Court case number 48 of 2016. And then the other one is Walksout versus the Republic. That is number 61 of 2012 before the High Court. Proudly, let me say that I appeared in the matters. What did the court say when somebody makes an allegation to do with somebody is going to interfere? The court did not say probably. The court said must put evidence, must show something, must produce something. Why? Because if we were to leave it to imagination, the sky would be the limit. So if you are saying somebody is interfering with witnesses, you must show that he directly interfered or indirectly or has attempted. In the affidavit that you have been given, nothing is there. They are saying likely. That was held by Justice Corriel in the Dwight Sagarai case and was also supported by Justice Lesit as she then was in the Richard David Alden case. If you're going to say somebody is going to abscond, what does the judge say in Lesit? She says that you must be able to show that an attempt has been made by the person to try and abscond. Not only that, maybe there's a ticket, plans of traveling, or arrangements made. So I'll ask you, Your Honor, and I will give you the answer. Have they given you that? Then the answer is no. Such that even in the case of Oyamo, when they are saying that public order and public interest and all that, the court in Oyamo versus the Republic, and this is a court of appeal case, and that is the law. What does it say? For you to say that there is public order and rest and all those things that they are saying, they must show. All this unrest that has been going on has not been because of the OCS. Tuesday, tomorrow, there will be an mandamano in reference to somebody else. Not here.
You know, we hope that goes on record. That matter of fact, we hope goes on record.
It's even on social media. And let me tell you why they can't tell me not to say anything about social media. In his affidavit, he said they got these issues from social media.
You know, if that counsel can go to social media, we just asking the court that as he says it from social media, please record it for us, we will use it.
Yes, Your Honor. And if that is the position that they are going to say and they are going to use it, let me tell you, Your Honor, it was not in relation to the OCS. It must be mentioned that it is the OCS and it must be accurate. Let us not generalize. That is why that law has never been overturned. Until today, it has never been overturned. So, what then does that leave the prosecution with? An empty shell, Your Honor. Today, they have come to this court, not, as I said, to do this case in a proper manner, but in bad faith, which have demonstrated, and an affidavit that does not meet the requirements of Article 49. And at least what we will come out from with here is that at least I've given them a definition of compelling reasons. Yes. Thank you.
Let me read. Cliff can mislead the court. Your Honor, for the public and the country to get that paragraph, that is the citation Cliff has said, criminal case number 61 of 2012, Republic versus Dwight Sagarai, in page 4. paragraph 3. Your Honor, the court is saying, for the prosecution, that is Owiti and my good friend Makori, to succeed in persuading you on this criteria, however, it must place material before the court